Do you understand what you're charged with?
No, I don't quite understand those no, I don't. I don't plan to plea. I guess I'll answer in a formative, but Demers is not acquiesced to quasi-juris.
Right.
I'm Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my captors.
Today's case features a prime example of smug defiance in the courtroom. This particular sovereign citizen walks in acting as if he's been captured, like some political prisoner, immediately challenging the judge's authority over him. Within minutes, he's rattling off the usual "I'm not subject to the law" routine, as if personal belief could erase a legal charge. The reality? That's not how any of this works. Sovereign citizens often claim they can opt out of laws they don't like, but in court, those claims crumble fast. Watching him try to outmaneuver the bench is almost surreal. And it raises the question, does he genuinely believe what he's saying? Or is this a performance meant to stall? Either way, this hearing quickly turns tense, and the judge is about to shut it all down.
Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those no, I don't.
What's your question in regards to what you're charged with?
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. I have there's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
Have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since you charged this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plea. I guess I'll answer in affirmative if Demers is not acquiesced to quasi
All right.
jurisdiction.
If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by
I'm
jury.
Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question, sir?
You need to be quiet for a moment, and I'm going to explain what the situation is.
When asked to confirm his identity, Gordy tries to split hairs, saying he's the man, not the person, as though a semantic trick will erase the charge. The judge explains the details. He's accused of driving while suspended. A. Second offense, carrying possible jail time, fines, and even a mandatory minimum sentence. Instead of addressing the charge, he pivots to claims of mistaken identity and constitutional rights, insisting he was simply transporting property. This is where the tactic turns risky. In court, making knowingly false statements under oath isn't just bad strategy, it's perjury. A serious criminal offense that can lead to years in prison and permanently tarnish a person's credibility. Yet Gordy keeps pressing his narrative, confident he can talk his way out. The judge listens, unmoved, and prepares to move the case forward despite his verbal gymnastics.
You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my captors.
Here's where the denial kicks in at full force. Even after hearing the potential penalties and knowing this is a repeat offense, Gordy acts like he's the one being wronged. He refuses to enter a plea, forcing the court to do it for him, and positions himself as a victim of the system. But here's the hard truth. Accountability isn't optional. When you've been caught driving without a license, especially more than once, the law isn't going to bend because you dislike the rules. And this pattern isn't unique to him. More and more sovereign citizens are showing up in courtrooms across the country, each convinced they've found a loophole that will set them free. What they're really doing is showing a complete unwillingness to take responsibility.
I don't understand what a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no
Mr.
claim
Cooley,
has been brought
Mr.
against
Cooley,
them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
Judge, I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial and for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law rights.
By the end of the hearing, Gordy is still clinging to the idea that the legal process is stacked against him, leaning on the argument that a victim needs to be present for him to be convicted. It's a common sovereign citizen talking point. But it's also legally irrelevant in cases like his. Driving without a valid license is a statutory offense. The state itself is the injured party. Whether he believes this rhetoric or simply uses it to buy time is hard to say. But the result is the same: wasted court resources and a defendant who walks away no closer to a resolution. The judge handles it with steady composure, but it's clear she's seen this routine before. Cases like this always raise a question. Are these defendants truly convinced of their own theories? Or are they just playing the system in a last-ditch effort to avoid the inevitable? Either way, the law has the final say, and in Gordy's case, the outcome isn't looking good.